All right, how you doing, everybody? Happy Sunday. We are back for another live this Sunday, 7 p.m. Eastern Time over here on Clark the Realtor's YouTube channel. As I always like to do, I just want to make sure I'm live in case we miss anybody that comes in. All right, we are live. So I always like to also tell people, if you're tuning in live for your first time, please don't forget to subscribe to the channel, like, share it, hit that notification bell if you're just joining us over here, and let us know in the comments where you're joining us from. And if you have any questions about the topic tonight, please don't go down in the caption and email our guest tonight. Her name is Whitney Knox Lee, and she is an attorney based out of the Georgia area. And so I'll have her introduce herself. And tonight we're going to be talking about estate planning, wills, trust, probate, and anything else you might have questions about. So as far as further ado, here is Whitney to introduce herself.
Yes. Hi, everyone. I just connected myself to the chat so I can answer and see those questions. My name is Whitney Lee, and I, as Clark said, am an estate planning attorney. I am based in Atlanta, Georgia. I am a native Seattleite, though, and I've been in Georgia for 12 years now. So my practice and everything that I'm going to talk about today is going to be specific to people who are living in Georgia, who are residents of Georgia. But I always like to tell people that if you're not in Georgia, this is still good kind of foundational information for you to then go and speak to a licensed attorney in your state regarding whatever it is that you have questions about. So take that kind of disclaimer as we answer some questions today. What I'm saying, if you're not in Georgia, may or may not be the law in your state.
Yes, so that's good for everybody to remember. However, she'll touch on some vague things, but it's always good, like she said, to follow up with legal, I guess, I don't want to say legalese, but I guess that's what you guys would be considered. I don't know. Attorneys or lawyers in your state as well. So how you doing tonight, MHOA? He says calling from 39 and 105 West. So MHOA is based out of Denver, Colorado.
You just know this?
Oh yeah, well, not because of those, not because of that. Because he comes to the channel all the time. He always tunes into the chat and has some wonderful questions, sentences, one-liners. So he's excellent. I love MHOA. And also Angela Matney, she is based out of Omaha, Nebraska, from a wonderful realtor colleague of mine in Omaha, Nebraska, named David Matney. So they are wonderful people. And we have Corey West on here. Clark, good to see you. Good to see you as well. So we appreciate everybody being here. If you're in the chat, if you're watching us live, don't be shy to jump in the chat. This is a perfect opportunity to engage in this conversation. So we'll start off with Whitney in regards to the simple questions. What exactly is estate planning?
Ooh, that's a good question. Before I start, though, I want to see, because I see Croy West got a Seahawk on his little situation. Are you in Seattle? Because I was just sharing that I am a native Seattleite. So I'm gonna wait for your response. But anyways, what is estate planning? So estate planning is a strategy that we are using in order to make sure that everything that we've worked hard for, all of our assets, our legacy, our family history is passed on in the way that we want it to be passed on. So this can include actual money or other assets, real property, homes, or it can really just be like the values that I have in my family. And within estate planning, there is a lot of different kind of devices, if you will, that you can use, or different tools that you can use. My specialty is in wills, trusts, and powers of attorney. And also, though, when I'm working with people, I encourage that they're getting life insurance set up. I encourage folks to take a look at their deeds of their homes and learn more about what the language on the deeds mean and how they own their homes. I encourage folks to have conversations about investing with financial planners and investment advisors. And then we also talk about elder care. So if you are somebody that's aging and in your late 50s, early 60s, thinking that you might need to rely on Medicaid for long-term care, then we have those conversations as well. So estate planning really encompasses a lot of different disciplines, and it's how they all work together to strategically make sure that your goals can be accomplished.
I love it. Hey, David. This is David, one of my colleagues out of Omaha, Nebraska. He's a realtor over in Omaha, Nebraska. Hey, David, thanks for joining. And then MHOA said Clark got 10 more subs. Yeah, I was at 1,000 subscribers and I got 10 more, so now I'm at 1,010.
Hey.
So
one of them was me.
Oh, well, I appreciate it. Thank you, Whitney. So in regards to, as you were saying, estate planning, and one of your like, I like that you said it encompasses everything, as far as just not only, wills, trusts, and probate and all those type of things per se, but also the life insurance and all those type of things. Because I think, again, as I mentioned to you prior to coming on, we as people don't look at these things in totality. And one question, David said, "Good evening, Whitney."
Hi.
One question I had before we jump into what are those type of things that you kind of hit on a lot, as far as the trust, the wills, the probate, is that I learned this from an attorney, and in regards to probate. So she had told me that every person actually has an estate. She said, even if it's the shoes on your feet, the clothes on your back, when you pass away, that's technically part of your estate. So I guess, could you lean more into that? Because I don't think people even think about that.
Yeah, often when we think about estates, like the word estate, we are thinking about people that are millionaires that have just a lot of stuff. They have a lot of money, they have multiple properties, they have, an electric gate that opens when they go to one of their properties. We're thinking about people that's got lots of stock, lots of other types of financial products. But in reality, your estate is everything that you own. And so you can be wealthy and have an estate, but you can also be just a regular schmegular person like myself and have an estate. Whether or not your estate is going to need to go through probate is going to depend on what is in your estate and how, or what are the ways that you are strategizing to avoid probate if that's what you want to do. The other thing that I'll say before we move on is, while minor children, technically, I wouldn't say that they're a part of your estate. They are, like, their care is something that you are contemplating in estate planning. Because here in Georgia, at least, the only way to authorize a guardian of a minor child is through a court process. And so through estate planning, you're able to identify who you want to be a guardian or a temporary guardian, and other types of things relating to your minor children.
David said, Clark, great point. I never realized that. And then Croy hit you back on Whitney.
Oh, love Seattle. Okay.
He said, I love Seattle.
Oh, it's a Kitsap. Oh, but cost of living sent you to Omaha, Nebraska, and Des Moines. Yeah. I can't go back. Like, I can't afford it there. Like, you can't, I don't know. I mean, unless you're in like tech at one of the big, places, I don't really know who can afford Seattle.
It's climbing up there in cost, huh? And so now kind of just winging our way into the whole the three different, I guess, points. So what exactly is a trust? And then we'll lean into what is a will. I guess you can kind of answer all in totality. A trust, a will, and then with a will, do you have to go through probate or not? Or the trust, you have to go through probate. So I guess.
Okay, so I'm going to start with the will because that's easier to then build from there. So a will is the foundational document that most people know of when they think about estate planning. In that document, you are able to decide who is getting your assets. You're able to decide who is going to be the person that is distributing those assets to the people or charities or whoever. And that person is called the executor or the representative of the estate. And you're also deciding who is going to care for your minor children. So a will is good. Everyone should at least have a will. There are downsides to having a will. And one of the main ones is that your family will likely need to go through the probate process in order to probate your estate. Many people think that if I have a will, then they're not going to need to go through probate, and that is just not true. If you have a will, your family likely will need to go to probate unless you have used one of the strategies to be able to pass your property to whoever you want it to go to outside of probate. And there are a number of ways to do that. One way to do that is through a trust. But other downsides of having a will are that if your family is having to go through the probate process, it's going to take time. Here in Georgia, 6 months is fast. Realistically, it's going to take between 6 and 18 months. And that's if it's not contested. But if it's contested, it will take longer. I spoke with someone recently who's probating an estate for a loved one, and it's been 6 years.
Ooh.
Because there's some property and family members in disagreement about what should happen to the property.
Wow.
Probate is expensive. So here in Georgia, we do not have probate tax, if you will,
Okay.
but there are states like California and New York and Florida and South Carolina. There are a lot of states that just to have your estate in probate court costs a percentage of the value of your estate. So say you live in California, your estate is $1 million. They have a formula where just being there costs, 3, 4, 5% of your estate, which is, $30,000, $40,000, $50,000. So it can be very costly. The other thing about probate and wills is that because it takes time, if you have people that are dependent on your assets, for example, your home, then they may not be able to access your home while probate is pending. If you have if you have someone who is dependent on the money in your bank account, though that asset may be frozen while probate is pending. So you got to think about that as well. So a trust then is a will on steroids. A trust is a contract. It does not have to go through probate court. You do not have to have a judge say, okay, I see that before she passed away, Whitney wanted to do this with her stuff. Go ahead and do that. A trust, you're choosing the trustee who will take over as trustee after you've passed away. And they have their directive to distribute your assets how you've laid out in that trust document. And because it doesn't have to go through probate, it takes, a couple of weeks for those assets to pass. It can be a more seamless transition. It's harder to attack. And there are what am I trying to think of? Dispute resolution strategies that you can build into a trust so that if there is an issue, instead of having to go to court, you're trying different things to resolve the dispute. And then a trust is private because it doesn't have to be filed in a court. So unlike a will that has to be filed in probate court, which becomes a public record, a trust does not. So those are the main differences. Trusts allow a lot more flexibility with how you are leaving your property. You can make conditions on somebody's inheritance. You can give, 5% of their inheritance at age 25, 5% at age 30. Like you have a lot of flexibility as far as how you want to distribute your assets in a trust that you do not have in a will.
And so, Corey said, yes, it's a dream, but Omaha and Des Moines is more of a reality.
A reality, yeah. Than living in Seattle.
This is my daddy joint. Hey, Dad. James.
Hey, Dad.
Hey, Sam. How you doing? Hey, thanks for joining us. And this is my cousin, Lang. Hey, what's going on, Lang? So as you were saying in regards to the trust, so basically, are they looking at it more as like an entity per se? That's why it doesn't have to go through probate court, because it's more of an entity, or recorded per se because it's more of an entity. I don't know. How are they kind of looking at it?
Yeah, I mean, I wouldn't characterize it as that per se. But there just is trust law that says the trust don't need to go through probate.
Okay.
It's a contractual agreement that you're making with yourself.
Hmm. And so I know they also say in regards to a trust that you have to make sure, say if you have real estate, do you have to make sure it's deeded into the trust, or can someone just say, I have a piece of real estate and it's part of the trust?
No, it's not part of a trust unless you actually have done something to make it a part of the trust.
Okay.
And there are times when you wouldn't want to put your real estate in a trust.
Okay.
So, federally, under federal law, if you put your primary residence into a home,
Okay.
then it is against the law. It's illegal for that mortgage company, if there's a mortgage on the home, it's against the law for them to accelerate your mortgage. However, if you put investment properties into a trust, they can accelerate your mortgage.
Okay.
So there are times where people may not want to put property into the trust for a variety of reasons, including implications that it may have on the mortgage. And so that's always something when I'm working with clients that we are thinking about. I usually have them contact their lenders and just confirm that there's not going to be any issues with their mortgage itself, and have the lender write a letter so that we also have that on paper.
Oh, that's good. That's good to know. Wow.
Yeah, and so transferring the home is a process of redoing the deed or doing a new deed.
Okay.
And so that deed transfers the home from myself, Whitney Knox Lee, as owner, to Whitney Knox Lee as trustee of the Whitney Knox Lee Revocable Living Trust.
Okay. And so Lang said, welcome, Miss Whitney. Thank you for educating us tonight. Yes, she is here to educate us. Ask questions if you guys have any, because this is the perfect time where you can do that to someone that is professional and knowledgeable in this field. So my dad said, what's the difference between state and federal law? So
Yeah, so every state has their own set of laws that deal with what is going to happen specifically in that state. So when I talk about that, I'm a Georgia attorney and I'm licensed here in Georgia, I'm only licensed to practice under Georgia law. So I cannot give legal advice to the folks who live in Nebraska because I don't know Nebraska law.
Yeah.
And what I'm saying about Georgia may be different about Nebraska. But federal law, there are some laws that also dictate what has like a maybe larger scale issues. So in this case, in regards to the investment properties, there was a case where it was appealed all the way up to the Supreme Court of the United States of America. And that case decided whether or not investment properties could have accelerated mortgages as a result of being moved into trusts. So that is going to be applicable with any trust anywhere within the United States, versus Georgia state law that is only going to be applicable in Georgia. But if there's federal law that's more expansive than state law, then federal law can be followed, is what's going to be followed.
Oh, wow. I like that. See, you learn everything all the time. This is great information because I didn't even know that in regards to, like you said, investment property and all that stuff. So that's interesting. So since we're talking about federal,
can I just, 1 second though. I just want to add to that now that I'm thinking about it, which is wills are state specific. A will is drafted under a state law as opposed to a federal law. And so if I have a will in Georgia, but I move back to Washington State, my will may or may not be valid in Washington State because it may or may not conform with Washington's law on what is required for a will to be valid. So I also suggest that when people move between states, that they get a new will if that is what they have. Trusts, on the other hand, are valid in all of the states. And one, because they don't require going through probate court, but two, because there are federal statutes on the uniform trusts. I can't remember the name, maybe Uniform Trust Act or something, bland like that, that covers what is legal, what is not legal for trusts.
And so I have a question about wills, because I think I talked to you about this when I met you at the event per se, where there was a person who created a will, and the person who they gave their real estate to sign the will as a witness. And then when they came to try to have said ownership per se, they said it didn't work because they were the person getting the real estate, but also signed as the witness. So how does that kind of work if you're the witness to something that you're getting in the will per se? I don't know if I'm saying it right, but
Yeah, you're saying it right, and you just shouldn't be a witness to something that you cannot be a witness to the signing of a will in which you're inheriting.
okay.
So typically what I say to my clients is we need 2 witnesses, they need to be over 18, they need to be of sound mind, they need to bring their IDs, and they should not be named in your estate plan, like just period, just to be safe. They should not be named. They should not be a backup person. They should not be inheriting anything. Strangers are great.
Okay. So I guess even hitting on the whole federal, and if you guys are on tonight in the live chat, please ask questions. We have Whitney here. She is an attorney, and in regards to like trust, wills, and probate and everything. So please ask questions. So in regards to we were talking too about like estate tax and inheritance tax, and we know Georgia doesn't have inheritance tax, but I had mentioned this to you because my aunt, she got hit with inheritance tax in the state of Pennsylvania. So I think there are about like 5 states when I researched last that has inheritance tax, and I know Georgia is more of a state tax. So can you tell us a little bit about like a state tax and what is it, and you know, I guess when does it kind of typically occur after inheriting someone's properties or whatever?
Yeah. So these are also known as death taxes.
Okay.
And it's essentially so under federal
Mhm.
law, because as everybody knows, we have federal income tax, for example, and then we have state income tax. And as residents of a state within the United States, we are paying both, unless you are in a state that doesn't have income tax, like Washington. So similarly, there are estate taxes, aka death taxes, on both the federal level and state levels. States can decide whether or not they want to assess an estate tax. So, as you mentioned, Georgia does not have an estate tax, but many states do, like New York. And so, what that is if your net worth, if the value of your assets is over a certain amount, then you will be taxed very heavily on anything over that amount. So for federal, that amount is 13.99 million. Most of us we don't need to worry about estate tax.
Yeah.
And I hear this a lot because people think they need a trust in order to avoid estate taxes. But revocable living trusts don't actually avoid estate taxes.
Mm.
But also, you probably don't have enough money to need to avoid estate taxes.
Okay.
Okay, now the state versions of the estate taxes are usually lower. And I think, matter of fact, in California, if I remember correctly, they are in the process of lowering it to like, I don't know, a couple of million,
Okay.
which when you think about the value of land in California, you can easily have a net worth of over a couple of million by just being a homeowner.
Mm.
So, anyways, the value of your estate also includes your life insurance. So if you have $1 million life insurance policy and $1 million home, then your net worth is at least $2 million as far
Mm.
as the probatable estate.
Okay.
Okay, so anyways, if I was under federal law, if I was a millionaire and had $30 million in my estate, then I would be taxed roughly for 15.1
Ooh.
million of my assets.
Wow.
And that tax is high.
Yeah.
I'm talking 30, 40%.
Ooh.
So when you have that much wealth, you are wanting to take special measures to protect your wealth from taxes. So
Okay.
usually that's where we get into more complex estate planning, where we are using different types of irrevocable trusts
Okay.
in order to shield your assets from taxes, but also from debt, from creditors who are trying to recover debt from you, from Medicaid or other government entities who are trying to recover assets from you. And so that is a much more, again, complex and like specific circumstance where if you are someone who is impacted by either state or federal estate tax, you will want to be working with an attorney who is very well versed in tax planning specifically. Okay.
Wow. Ooh, that is a lot of money. Lane said, "Wow, she
It's
said
a
that's a
lot.
lot
Yeah,
of
yeah,
money."
yeah. So most of us don't need to worry about it.
Yeah.
I don't need to worry about it.
Yeah, me either. My dad said, "Can you be hit with both federal and state tax?"
Yes. So for estate tax, yes, you're liable for both the federal estate tax and the state estate tax.
Wow.
Okay. And then there's also gift tax though.
Okay.
So and gift tax is state and federal as well.
Okay.
And I want to say the number is $18,000. So if you are someone, and what I recall now, take this with a grain of salt because I also usually don't deal with people that are doing this.
Yeah.
So one thing I should say about my business is that I work primarily with Black and brown folks and with first time estate planners. I do not work with people that have millions upon millions upon millions of dollars. And I also don't work with people that give $18,000 gifts to people. But from what I remember, that threshold number is $18,000 per gift. Now you can make a cajillion $18,000 gifts to a cajillion different people, but you cannot make more than $18,000 gift to any single person. And so you are going to be taxed, or they will be taxed for an amount that is over, if they receive a gift from you, that is over $18,000. Okay, so that is something that we also need to think about because even when we have passed away and we are leaving something to somebody, most of the time estate tax is not going to be implicated, but there are times when it would be. And so again, that's something that you want to think about as you are figuring out what to do, who to leave stuff to, if you want to gift stuff before passing away. And it's annually. So $18,000 annually per person.
Oh wow. Okay.
So,
David,
but like I can give an $18,000 gift to everybody in my family as long as I don't go over $18,000 for any
every
one
year
of those people in a year. Yeah.
Whitney, David said, "Whitney, what is the most common mistake you see with someone with a trust?"
It's not funding the property into the trust. They think that because they went on LegalZoom or ChatGPT and created a trust that is all that has needed. That's all that needs to happen. And so they have their trust, but they haven't actually funded anything into the trust, which means you're not using the trust. You're not getting any of the benefits of the trust because the trust can only benefit the assets that are owned by the trust. So it's like buying I don't know, Prada bag.
Okay.
But then not putting anything in that bag to carry it around with. Like you're just carrying around this empty Prada bag. Your wallet's not in there. Your, I don't know, jewelry isn't in there. And now you're expecting all your stuff to be in there. It's not.
It's not. That makes sense. David said, "So if we give Clark a super chat, we need to keep it below 18K." All right. Well, that would be a wonderful super chat. David said, "Is that why those who have extreme wealth have foundations?"
There's a lot of tools that people use. Foundations, yes, because you get tax breaks if you are giving away money. Irrevocable trusts, having other types of entities. Yes.
So, well, I'll jump into some of the questions that I have here. So don't mind me. If you guys have questions too, don't forget to ask those questions. So, we kind of already talked about, the difference between the trust and the will. Can you make more mention to? I heard you talk about like revocable, irrevocable. trust or whatever is what is the difference between them? Because are they interchangeably, or like what is the difference between an irrevocable and revocable trust?
Yeah, so I mean, primarily well, I shouldn't say that. The name gives you some hint. A revocable living trust is a trust that you can make changes to and you can revoke it altogether.
Okay.
So whatever decisions that you make regarding creating that trust and funding that trust, they don't have to be permanent. You can make changes to that whenever you want to, as
Okay.
long as you're still living and of sound mind. An irrevocable trust is it's very difficult to make changes to. It's not impossible, but it is difficult. But the thing about, so there are three relationships involved with a trust.
Okay.
There is the trust maker or the grantor. I like to call it a trust maker because it's clear who's who.
Mm-hmm.
The trustee, that is the person who is managing the trust. They are going to distribute whatever's in the trust to whoever it's supposed to go to. And then there's the beneficiary, the person that's receiving. When you are living and of sound mind and able to care for yourself, if you're making a revocable trust, then you are all three of those things. You are the trust maker, you are the trustee, so the person managing, and the beneficiary. You're benefiting from what is in your trust. For that reason, the IRS and really federal and state law don't consider ownership of the property to have changed, because you as the trustee still have control over the property for all intents and purposes.
Okay.
With an irrevocable trust, most of the time, with most types of irrevocable trusts, the trust maker is not the trustee.
Mm-hmm.
So the trust maker puts a house into the trust. They appoint somebody else to be the trustee.
Okay.
And now that somebody else has control over what's in the trust. And the trust maker does not.
Okay.
And so because there's that kind of severing of who has control over the property, it's those types of trusts that allow debt protection, creditor protection, sometimes tax protection, depending on the type of trust, for irrevocable trusts.
Okay.
But what you gain in terms of protection, you lose in terms of flexibility and control. So there is a trade-off.
Okay. So you can't just, like you say, you just can't go and try to change it because you're not attached per se to it no more. Okay.
Yeah, most people are going to get an irrevocable trust for a specific reason, for a specific goal. And most of us don't need an irrevocable trust. But some people do.
Okay. Yeah, because I always hear people talking about too, like a living trust or whatever trust, but I'm like, it seems like it's just revocable or irrevocable. And I guess they just add on the living trust because they're living. I don't know. That's what I hear people say a lot. I don't know.
Yeah. I mean, that's just the name of them, revocable living trusts, and then an irrevocable trust. There are many types of both, really. There are many types of irrevocable trusts. The one that I am most familiar with and that I help my clients with is the Medicaid Asset Protection Trusts.
Okay.
And it's specifically for people who are going to need Medicaid for long-term care, so for nursing home care or in-home care as they age. They have assets and they need to become eligible for Medicaid, but also after they pass away, they want to be able to transfer their property to their family and protect it from Medicaid asset recovery. And so Medicaid asset recovery is essentially where in most states it's, at least your home, but here in Georgia, Medicaid can go after your entire estate. If Medicaid is paying for your health care, essentially, then after you die, they are going to sue your estate to pay themselves back for what they've spent on you.
Wow.
So we use Medicaid Asset Protection Trust to protect those assets from Medicaid, but there's a lot of planning. Primarily, like the number one thing to know is that you need to put this into place 5 years before you might need Medicaid. There's a 5-year kind of waiting period of
Wow.
you have to have transferred property 5 years prior. So that is also a complex planning
Yeah.
strategy that, you know, is very specific to circumstances. So, but I will say that if you are between 55 and 65, maybe 70, still in good health, and you don't know how you're going to pay for your care as you age, or you don't have a family member that has committed to taking care of you, then you do urgently need to go speak with an estate planning attorney who also handles elder law issues, who can talk to you about what your plan is, because you need a plan, because aging ain't free.
Wow. David's saying the same thing with me. Wow. Like this part of creating, like putting things in the trust, this is very complex, very interesting, and very much knowledge that people need to know. So we appreciate you, Whitney, for being on here, just having these conversations. Because I didn't even know that either. That's crazy that Medicaid can sue you for wow. Okay, that's interesting.
Yeah, and also, I mean, there's a lot of conversation happening right now because we just don't know if there's even going to be Medicaid down the road. So like it's something that we need to think about. You need to know about, you need to plan for, but also there might not be Medicaid anyways.
Wow. So my dad said, if there are two names on the trust, are both equal? So I guess if there's two, I guess I don't know if there can be two beneficiaries. I guess he's saying, as far as let's say someone owns a house and they put two people's names on in the trust to get the house, and then when they pass away, the people have to sell the house. I guess he's saying, can they split it equally? I'm guessing.
It depends on how the trust is written.
Okay.
There are some people who will want, specifically in terms of really everything besides a house. A house here in Georgia, as you know, is a little bit different because you don't,
Yeah.
if you are a joint owner of a home, it's not treated as if it's 50-50.
Yeah.
So for everything relating to, or except for a house,
Mhm.
you can decide like, okay, this person gets 1/3 of the asset and the other person gets 2/3.
Mhm.
So usually in your will or your trust, you're going to specify what specifically the beneficiary is inheriting,
Yeah. I'm
down
like,
to like, if they sell the house, this beneficiary gets 30% of the proceeds, another beneficiary gets the rest.
I had a bunch of questions for Whitney, but this is getting so good that I kind of went off track. So Whitney probably like, what the questions you sent me? You're not even.
No, I'm fine. It's good.
But
I talk about this stuff all day, every day. So
I'm like but also Corey, he said, wow, this is good. I'm learning things I didn't know I needed to know. Yeah, everyone is so interesting as we start to unpeel the onion, per se, the layers of depth and different information. You never realize how much you need to know. So that's again, we appreciate Whitney being on here tonight. So I have a question too, because we do know in Georgia, as far as when you take title, we have like tenants in common, joint survivorship. So how does that kind of work? I know you mentioned it earlier as far as the way we take title in the state. How does that work if in a trust per se, or in a will per se, I guess?
yeah. So backing up, I know that a lot of folks that are watching are in real estate, but in case you're not, there are two ways primarily that people own land here in Georgia. There's three ways. One is by contract, but we're not talking about that.
Yeah.
The two ways that we're talking about are they can own it. Well, first, they can own it individually, right? So I am just the sole owner of the land. Great. But they can also own it jointly with other people.
Mhm.
And so, of the people who own land jointly, there are two types of relationships. There is a tenant in common, and then there's a joint tenant with right of survivorship. Up until I believe it was 1976, the tenancy in common was the default. And what tenancy in common means is that both people own the home. When one of them passes away, if it's two people, but if it's five people, everybody owns the home. When that person passes away, their share goes to their heirs. That was the default. So if you passed away without a will or without a trust, and you own the home with other people, then your share of your home is going to be passed to your heirs. That in contrast with a joint tenant with right of survivorship, which in other states is called something else. I think some states might call it like tenants in equity or something like that. But here in Georgia, it's joint tenant with right of survivorship. What this means, I call survival of the fittest. You can own the home with multiple people, but it's the last living owner who actually gets to pass the property. So if I am an owner with 2 other people and they pass away, they are not transferring their portion of the property to their heirs. Their portion of the property is now just split between me and the other owner. And then whoever survives out of those 2 people is the person that gets to pass the land. Okay. So as far as trusts go, when I am doing trusts, I'm severing that joint tenancy.
Okay.
First of all, because it doesn't make sense to have when you're putting it into a trust, it's the trust that is going to determine who gets what. And if you have made that decision, but it's different than the co-owner, then it's going to be a conflict and somebody's going to sue to try and recover, like it's just going to be trauma. So I sever the tenancy, put the home into the trust. Usually it's like husband and wife. Me and my husband own a house as joint tenants. We would sever the tenancy, put the home into a joint trust. So now we both still own it because it's our joint trust. And then we, distribute however we want.
Okay.
For tenants in common, you can still put the property in the trust, although you're only putting your share.
Okay.
So you can still leave it to your heirs in trust, but I don't do that.
Okay.
I don't put jointly owned property in trusts unless the trust is a joint trust with the only owners. If there's other property that they own, like I had one client who owned property with a friend, great, good for you, but that's not going in this trust. That's just going to stay where it is outside of the trust.
MHOA say, hence the murder mystery. David said, what happens to someone's credit card debt after death? Can credit card company go after the equity of the home?
So yes, the credit card company can go after the estate to recover their debts. And once somebody's passed away, they are supposed to pay, the estate is supposed to pay their debts. Now, some debts will be discharged. And I think it depends on the debt that it is. And then here in Georgia, there's also a way to, even if there is debt. So, okay, in Georgia, even if there's debt, the surviving spouse and surviving minor children, they have like the first claim to the estate in what's called a year's support action. And that is basically the dependents of that decedent saying, we relied on this person financially, and now they're gone, and we still need their house or their income or whatever. And so we are asking the court that instead of paying their debt off with their estate, that you provide us with a certain amount of the estate to give us what's called year's support. So that's a way of getting around debt. But what I should say is that if you pass away with debt that is not attached to anybody else, there aren't joint debtors, what the creditors cannot do is go after the family members here in Georgia. So like the living spouse, if the debt was a credit card of husband, but only husband, the credit card company can't sue the spouse.
Okay. That makes sense. Hopefully I'm saying her name right. Francine Cook. She said, I have several plots in different states. I would like to put them all in a trust, living revocable or irrevocable. I'm confused. So she's
Yeah, it's confusing. It's gonna depend on really the value of your estate and your goals with the estate. A revocable trust is gonna be just fine in a lot of instances. If you're thinking of something like a dynasty trust where it lives for generations, generations and generations and generations, that's an irrevocable trust. So it's really just going to depend on what is your goal. Is your goal to make sure that, you know, 2 generations down, they have what they need, they're able to sell the land and take the money and go to college or whatever? Or is your goal to protect the land from your creditors? Or is the goal just to make sure that the land gets to the next generation without that generation having to go to probate in each of these states?
And like you made mention earlier, people don't realize it a lot that if you do have she said, thanks, Francine. If you have any questions, please put it in the chat. David said that is good thing to know as far as the credit. When it comes to, as you made mention too, in the state of Georgia per se, and I don't know how it works in other states, but if you have a will, you still have to go through probate. I think most people don't realize that you still have to go through probate. I have a fly here. Sorry. Most people don't realize that you still have to go through probate even if there is a will.
Yeah. And so even if you own property, like Ms. Cook is saying, in multiple different states, what that means is that after you've passed away, if you don't have a trust, your loved ones may need to go probate in each of those states. There are ways to get around that. For example, if there's a joint owner for that land, then those parcels will automatically vest to the joint owner. But if there's not joint owners, or if you want to leave the land to somebody else to own it, it's really just dependent on what your goals are. All of this. That's why I like to use the word strategy, because it is very specific to the person and what that person's needs and goals are.
And that's why it's always great to meet up with an attorney, sit down and like like Whitney said, like talk about what is your ultimate goal. Have these, ask these questions, have these conversations, because ultimately, what are you trying to do? That's even when it comes to real estate too. Like as a realtor, we sit down, we ask questions like, what is your ultimate goal, right? And so I'm going to look down to see some more questions. If you guys have any more questions, let us know as well. David kind of answered the whole creditors thing because I had that in one of the questions. So, and we kind of talked about that as well. I just want to see what we kind of missed. There was another question I had for you too in regards to, I think, well, my dad kind of threw that question in there as far as multiple people owning stuff in that estate. So I have a question too in regards to when someone is younger. So say you have a young child, right? You're an only parent per se, you pass away and you put things in the estate, or you have a will per se. How does the child end up ultimately gaining that asset?
Yeah, so children in Georgia can't inherit large amounts of money. They can't inherit like a home. They cannot, if you got $1 million life insurance policy, they cannot inherit that until they turn 18. So that is the thing. Until they turn 18, they can inherit all of that stuff. Okay. But somebody else is going to actually be in charge of it until they turn 18. And at the point where they turn 18, it is given to them. So what's important to know about planning, if you have minor children, is one, a trust is going to be great for you at the minimum, because you're able to house those assets for the sake of your child within this trust. And the trustee is responsible for distributing the assets throughout the child's life, however you have said, and for health, education, maintenance, and support, those 4 things, throughout the child's life. So you have $1 million life insurance policy. Instead of making your minor child the beneficiary, you make your trust the beneficiary. Then when you pass away, the $1 million goes into the trust. There is a trust bank account, and your trustee is accessing that bank account to be able to give to the child's new guardian to spend on the child moving forward. If you don't do that, then here in Georgia, the state will make a trust for you. And anytime the child needs money, their guardians have to petition the state to ask for money.
Wow. Okay.
And then at the age of 18, the child gets everything.
Okay.
So I don't know anybody who wants their 18-year-old to receive their entire estate.
Not an 18, no.
Right. So there's a lot of benefits to having a trust. And a will is not going to do this for you. A will is just going to say, I leave this to my kid. But it's not going to say, I leave this to my kid, but not until they are 25.
Yeah.
So, yeah, that's definitely something to keep in mind when you have minor children.
And so I guess another thing too, okay, say if I put my house into a trust, a deed into trust, and then I sell it per se, right, before I pass away. Will I be able to, how does capital gains might work in that? I don't know if you can kind of bleed into that, because I know you can also talk to like a CPA and accountant per se, but how does that kind of bleed into selling your house and the capital gains tax?
Yeah, so I don't want to go too in depth, but because it depends. Okay. But in general, so the capital gains tax is the tax that somebody pays after they have sold the home or at the sale of the home, and they're paying a tax on the amount that the home has appreciated during their ownership. So when you inherit property, you receive a step up in basis, which is essentially, instead of the appreciation of the value of the home being determined from the time of the decedent's coming into ownership of that property, it starts at when you inherit the property. So then if you sell the property immediately, there's not that capital gains tax, really. I mean, there might still be a tax, but the appreciation is very small. Versus if this is what one mistake that I see a lot. In order to avoid probate, the parent will add the child onto the deed. What that does, yeah, it's great. The child is now part owner of the home. They don't have to go through probate to get the home. But if the child doesn't want the home and they're just going to sell the home, now they are paying the capital gains tax starting from when the parent purchased the home. And so then there is going to be that large appreciation, especially, I know, Clark, and many on the call, my home during the couple of years of COVID appreciated like 30-40%.
Yeah.
So people have to be prepared to be able to then pay that tax. And if there's a mortgage on the property, then, you're chipping away at the equity of the home. So that's really where capital gains comes in, is, you get the step up in basis benefit if you inherit a property, versus if you are just transferring a property while you're still living, and then the people that received the transfer sell the property, those people are the people paying the capital gains tax.
See, that's good to know, because like you said, I know a lot of people who have done that, where they have actually put the child name or another person's name on the deed because they don't want to have to worry about them going through probate. But that's good to know. That's a gem right there, you got. Oh, go ahead. Sorry, what were you about to say, Whitney? I'm sorry.
Yeah, I was just gonna say, it's this is the type of thing that we see a lot in our community of Black folk. It's this kind of like trying to hack the system that I warn people against, because it could wind up costing you thousands and thousands of dollars, or costing, we'll say, your family, the generations that come after you, thousands and thousands and thousands of dollars. You thought you were saving some money, but in reality, you're making it so that other people have to pay a lot. But I do see that, Mr. Clark, your father asked about if a child is on the deed, is it necessary to have a trust? My answer is, it's going to depend on what your goals are. If your goal, and if your only asset is this home and the child is already on the deed, then no. arguably you don't need a trust because the only thing that you are passing already has a way to pass without going through probate. Now, the reality is most of us have more than just a home. Like we got maybe personal property within the home.
Yeah.
We have bank accounts, we have life insurance, we have other things. And so if you want to pass those other things, then you might not need a trust, but you at least need a will. Because again, like a trust is great if you want to avoid probate, but maybe you're not concerned about probate. Like you don't care it's going to take a year and a half. You don't care it's going to cost between 1 to 9% of the value of your estate. You don't care that it's public. Okay. You can just do a will.
Okay. So like me and my dad, I know we're almost at time, but I have like 2 more questions. And if anybody else has questions, kind of put them in real quick. So one question is that I know in the state of Georgia, we just adopted a thing called, and Lang has one. So I'll do mine, then I'll do hers so I don't keep, but we had adopted a thing called what's it called? The TOD now, the transfer
on death deed.
On death deed. And one of the attorneys had made mention to possibly doing that, like once you purchase your house, kind of getting that kind of laid out up front. So I guess I don't know how many states kind of do that per se, but is that a good way to go as far as transferring property as well? What do you think?
Not here in Georgia yet.
Okay.
So if you are in Georgia, the legal community and the real estate attorneys really do not trust the transfer on death deed yet.
Okay.
Because there are a lot of questions. The law is vague, and how it actually applies in the real life is unknown. Okay. I've had one experience with my mother-in-law. I did a transfer on death deed for her, and the homestead exemptions office made the beneficiary the owner like today, before my mother-in-law passed away. And if she weren't my mother-in-law, you know, like she was my test case because of our relationship, right? So I couldn't follow it up and fix it if something happened. And of course, something happened. So it was a morning of me in downtown Atlanta trying to figure out how to fix this. Okay. So there's a lot of questions. And so I do not use that for clients right now. Okay. In other areas, in other states, it's called the Ladybird deed. And yes, that might be a good option for transferring property.
I like that's all these small little nuances. It's just so like you said, what steps can I take now to help my family avoid probate or minimize estate taxes?
So I'm gonna start with some free things that you can do. As far as your bank accounts, financial accounts, you can have beneficiaries for those. Beneficiaries should be over 18. They should be people that you like. They should be able to manage whatever it is that you're leaving them. So keep your beneficiaries up to date on those insurance policies. But you can also have payment on death designations for your regular old checking account. So have that in place so that if you pass away, somebody can just show up with your death certificate and their ID and claim the money in your bank account instead of having to go through probate. If you are a homeowner and are not concerned about step up in basis or capital gains tax, then you can add somebody as a joint tenant with right of survivorship onto your deed, which would make it so that when you pass away, they get that deed. If you live in a state that has a Ladybird deed, that might be a way as well. My understanding is that in many states, the Ladybird deed does bypass probate. Okay. Talk to your family members about what you want to happen. Like, what is your plan and what are your goals? So that they can be working with you on making sure that those things happen. And maybe that means transferring some things while you're living. As far as minimizing estate taxes, again, unless you make over $13.99 million, or unless you have over than $13.99 million, you do not need to be concerned about federal estate taxes. If you are living in a state that has state estate taxes, you will want to be clear around what that cap amount is, and then you'll make plans for what to do with any overage. And with that, you do need to go speak to an attorney.
And so me, I know we're at the 8 o'clock hour, but I'm going to get us out of here because I know you have, your family go back too. So in regards to like even the whole thing with the bank like you were saying, as far as the beneficiary, I initially had me and my dad, he kind of placed me on his account as a beneficiary, but then we went back and we just created a joint bank account. I don't know if that was good to do or not, but I felt like when we sat down with the banker and we kind of went through everything, it was like this, will create a little bit more ease per se. If he happens to pass, and I can just access the funds. Of course, we don't want my dad to pass, but but we try to think ahead because we know in
Everybody
reality,
dies.
everybody dies. Yeah.
Yeah, and joint accounts work. There's benefits and negatives.
Okay.
A negative is that now somebody else got access to your money.
Yeah.
Like, so not everybody wants that.
Yeah.
But in some cases, it is helpful for people to have joint accounts. So
And
it's also going to be maybe an issue if your father needs Medicaid in the next however many years because it counts as a transfer. And so there are some things,
Okay.
but again, it's highly specific. The strategy is specific to you.
Okay. And then what else I was going to say? Let's try to.
Oh, how often? Yeah, to update your estate plan. Anytime there are major changes in your life. So what life changes can trigger a review? Death or birth of a immediate family member, or a disability of somebody that is impacted by your estate plan, a dependent, a move to another state, retirement is a time to check your estate plan. And then if none of that happens, I'd still say every few years, I offer to my clients an annual review just to ask them like what's changed and see if any of those things might warrant changing their plan.
And David said, great guest tonight. Thank you, Whitney. Yes, we appreciate Whitney. We're going to get her out of here. My dad said, thank you for the info. Really appreciate it. Lang said, great. Beneficiaries, bank accounts, and home. Deed, a plan and goals. Thanks. She said, thank you. And then Corey West said, Clark, can you do a part 2 perhaps in the near future? If Whitney is willing to come on and to sacrifice another hour of her time, because she does have a family, a husband, and a child. So we totally appreciate her. We're going to wrap it up here. Just because we want her to get back to her life. But
I'm happy to come on again. So,
okay.
Because we didn't talk about powers of attorneys.
I know.
There's some other stuff we could be talking about. So yeah, if folks have other questions, you can feel free to reach out to Clark and we can get a list going and do a part 2 with those questions. Yes.
And if you guys have questions for Whitney as well, outside of this live, and you can reach her at Whitney at willsforthepeoplegeorgia.com. Again, she is licensed in the state of Georgia. She handles attorney matters per se, probate, wills, and trusts and everything in Georgia. But it's always great if you just have, want to reach out. Maybe she might know of other attorneys in different states that she might be able to link you with. So her information will be below as well in the caption. I'm going to go back after the live. I'm going to put everything down there. So if you're missing this live right now, you want to reach out to her later on, find her information below in the caption. So I'll keep this up real quick. And then MHOA said, we appreciate your time, Whitney.
Yes, absolutely. Thank you so much for having me on. Definitely talk to your family members. If there's one thing I want you to take, this is a conversation that we need to normalize within our families, whether or not you are in a financial situation to be able to get an estate plan from a licensed attorney. We need to be having these conversations with our family members and sharing information, truthful information, real actual information.
Yes.
Not TikTok information.
Exactly. So on that note, we're going to jump off here. If you can hold on in the back real quick with me when we jump off. So, and then again, thank you guys for tuning in tonight. Again, if you're just coming to the channel and seeing it live, go back and watch it from the beginning. Don't forget to let us know where you're tuning in from. Don't forget to subscribe, hit that notification bell to make sure you get all the videos when they come live or be uploaded. And we'll talk to you next Sunday at 7 p.m. Eastern time. Thank you guys again for joining live, and we appreciate everyone who was in the chat with us tonight. All right. See you guys.